30? 38. You want it after 10 days? All right. On the request made by Mr. K. Gogoi, landed CGC, matter stands deferred to be listed after 2 weeks. Mr. M. Sahiwala appears for the petitioner, who submits that the matter be listed on a fixed date. List on 15th September. Yes. Next 27th. All right. 27th. Yes. $27. 27th or 27th? Yes. $29th. First week of September, all right. Third. Yeah. Withdrawal. Tomorrow? Hmm. 29th. Monday is a holiday. 29th. Change the date, 29th August. Contempt, 29th. Huh? What is the subject matter? Compassion. How many matters? How many matters you want to be listed? Only one. All right, 29th. 51. 41. 41, how much time do you require? 3 weeks. 41 on the request made by Mr. N. Upadhyay, but still deferred to be listed after 3 weeks. List on 19th September. Mr. D. Chakraborty for the petitioner. Yes. For listing. What matter? What is the subject matter? Pension. All right. Have it on 1st of September? 1st September. Yes. Subject matter. Condonation of delay. 1st September. $53. All right. Your served copies. Okay. That MOA agreement, power of attorney. All right. Contempt. 1st September. Item 1. None appears for the petitioner. Office note reflects that the process server has given a report about service of notice on respondents 1, 2, and 4, and also AD card in respect of respondent number 3 has also been received. Stop. Accordingly, service on all the respondents stands complete. Matter therefore be listed again after 3 weeks.
Item 2.
Where is the direction? If I heard counsel for parties issue notice, returnable 4 weeks. Steps on respondents. Opposite parties be taken within 1 week by registered post AD as well as usual force.
Item 3.
Bench 2 matter. This is DLC, SLC. Counsel for the petitioner submits that this matter has been wrongly listed as it pertains to civil bench 2. Stop registry to verify and place the matter before the appropriate bench. List on Friday after verification by the list on Friday after verification by the registry. Your name? B. Daka, APS for the Education Department. Yes.
Item 4.
Yes. Mr. A. Fukan, counsel for the GAD department, submits that the matter was taken up for hearing on 8th or 1st. Although fixed on 8th, it was subsequently rescheduled on, although fixed on 1st, was subsequently rescheduled on 8th. And thereafter, the concerned appeal, it is before the appellate authority. Appellate authority had concluded the hearing, but orders are still awaited. Counsel of the bar therefore submits that the matter be listed after 10 days. After 10 days, on a date to be fixed by the registry.
Item 5.
We'll issue notice at this stage. Heard counsel for parties issue notice, returnable 4 weeks. Steps on respondents. Who's for the respondents here? Public health. Who appears? Who's for public health? The respondents are represented by Mr. R. Gogoi, appearing for respondents 1, 3, 4, 1, 3, and 4. MSS Boro appears for respondent number 2. Since the respondents are represented, notices are waived. The extra copies be furnished within a period of 1 week from today. List after the matter be listed after 3 weeks. After returnable date, names of all councils, including government council, be reflected in the cause list.
Item 6.
Yes. Some affidavit is filed. Are you you're not filing rejoinder? Hmm. Yes. What admission hearing? You're keeping somebody on suspension without any authority?
Hearing in the month of October. Going due procedural and with the approval of the constituent. After review of the data by the executive authority, the substantial period of the question under the paper was extended for a period of 3 months. With effect from 28/7/25, for the event. Then say E. So we can sort of. They have failed to control in the period of 3. There are certain of our high court. Whereas I know. Of general application has laid down, and wherein it has been laid down, the review order has also to be passed within the period of 3 months. And that having not been done, order is has lost its force matter, and he is liable to be in suspension. So one is the suspension. But on 28th November 2024. The periods of 3 months come to end.
No, as per the memorandum, it is 6 months.
But review has to be done in the 3 months. There are various concepts from our record.
But this office memorandum is not challenged.
Not required, my lord.
Why?
Because the office memorandum is changed.
This office memorandum is pursuant to a judgment of this court. Let us see what judgments are there. What is the stage of the proceedings?
And convert to better and another aspect is, my lord, it's review and order and then retrospective issue. That review has not been done within the period of
Review.
retrospective effect. The review order is that next are 5. Next 5 at page 55.
This is on June, 6th of June.
Of 28/5/2020. So that 6 months came to end on 28/5/2020. So that has been given retrospective effect. And my case is covered by this recent judgment of our High Court that was in absolutely same text violation. In that case also, though in my case, the review also has not been done within the period of 6 months. In this case, review was done within the period of 6 months, but not within the period of 3 months.
Do you have the judgment of Ajay Chaudhary with you? Hmm. Yes.
Therefore, direct that the current thing of a suspension order should not extend beyond 3 months if within this period the memorandum of charge sheet is not served on the delinquent officer employed. If the memorandum of charge sheet is served, a reasoned order, this is important. A reasoned order must be passed for extension of the suspension. As in the case in hand, the government is free to transfer the person concerned to any department in any of its office within or outside the state so as to survive any local or personal contact that he may have and which he may misuse for obstructing the investigation against him. The government may also prohibit him from contacting any person or handling the record.
You see, this can be interpreted in two ways. Firstly, no suspension beyond 3 months. If you don't serve the memorandum of charges. But if the memorandum of charges is served, then what is the limit? When? Within?
Immediate, because
That these, how can a judgment of these High Court clarify a Supreme Court judgment? These are judgments. How can the High Court clarify a Supreme Court judgment? No, don't give us names. Names don't help us. Whether it is by X or Y, these are orders of this court. You see, what we are trying to tell you is, what we want to understand is, there is a set of rules. It's called the Assam Disciplinary and Appeal Rules. These rules have not been amended. Neither have any provisions of these rules been challenged before this court, in spite of so many orders, in spite of Ajay Chaudhary. In Deepak Mali's case, it was a mandate of the CCS rules. Therefore, the court interfered. We do not know what rules were applicable in Ajay Chaudhary, but so far as the state of Assam is concerned, there is a set of rules. Those rules were never called in Ajay Chaudhary. So, ordinarily, yes, within 3 months you have to give. That apart, pursuant to an order of this court, there is a memo. There is an OM which was issued. The recent order, but for extension, but 6 months. No, let us see the memorandum.
Memorandum is that case.
This is again the 3 months. If
in 3 months of suspension, a reason must be passed for extension of suspension wherever. If it is necessary for extension of the suspension, then a reason order also must be passed.
Correct, but it will require this. No, but has it been interpreted here in the judgment?
Yes, and there they want to extend further.
Then we'll have to examine this matter. Let it come for admission. Heard counsel for parties since next week. Counsel for the respondent submits that the affidavit has been filed. counsel for petitioner submits that he would not like to file a rejoinder affidavit to the affidavit in opposition filed by the respondent. Stop as agreed to by both counsel. The matter be listed for admission hearing on 26th, 26th, 28th, 26th.
Item 7.
Affidavit. Ms. S. Borwa, Learned CGC, submits that she'd like to file an affidavit and prays for 2 weeks for the time. Mr. V. Kumar, counsel for the petitioner, does not object to the prayer made. List again after 2 weeks. Interim order passed earlier will continue. List on 5th. 5th September. Huh? Item 7. All right, same order. This is item number. Okay, this is item 7. You are appearing. Mr. B. Pegu. B. Pegu appears. CGC. G. Pegu, sorry.
Item 8.
So some wrong information. Let her obtain the instructions. How much time? If you're not called, you're not called. We can permit you to participate. If required, subject to the outcome of this writ petition, you will have to conduct a special physical test if required. You get your instructions on, you give us your instructions on Friday? Next week. Not next Friday. 27th. 27th. On the request made by Ms. S. Borwa, Learned CGC, matter stands deferred to be listed again on 27th. As the counsel for the petitioner, Mr. Roman, submits that physical what test? Physical standard test and physical efficiency tests are being conducted by the respondent authorities, and the petitioner will not be permitted to participate in this. Considering the urgency expressed list on 27th.
Item 10. Item 9.
Yes. Yes.
And I can opt for an deprivation. So I opted for the MI, the election person, and I was election on 2110. Now, what happened that the IG agree on the permission was also given. Now, what happened on 15/2025, so what was given to me by the superintendent of this. On 16th to I had given my employer project when the matter goes there. After 3 days, on 19th to, on the 19th to the home and the political institutions that allows me to go for the deportation. And what happened on 14/4, on 4/4 actually, I received another so-called notice on the same instance from the IG. The thing is in a page number 39.
We'll issue notice today. Heard, counsel for parties issue notice returnable 4 weeks. Mr. J.K. Goswami, learned senior, additional senior advocate, represents all. 1, 2, 3, MS S. Borua for NIA. Who appears? All right, appears for 1, 2, and 3. Therefore, notices are waived. Extra copies will be furnished within a period of 1 week from today. Steps on Respondent 4 by registered post AD as well as usual course. Matter be listed after the returnable date.
Item number 10.
Hmm. Then what will happen to the counseling? How long is it going to take? No. Counseling will continue till? Yeah. You participate because we can't direct them to issue without verification if there is an objection raised. What is that procedure?
District level, by the task committee, the subsequent authority to verify the outcome. Because a valid certificate is issued by the deputy commissioner, Morigaon. So district level committee is the first authority. He has to show for that procedure. That will take long time. It takes long time to seem to deploy, but then possibly direct has to participate and subject to outcome of this retreat. Outcome the result of the money that procedure. The rest will be great. Because the compliant authorities do the deputy commissioner for the verification is of the service.
What is this MOM referred here? There's some MOM referred, resolution point number 3. No, but it is not.
If it is cancelled,
No, but it is not. You have not submitted in the proper format. It doesn't have a countersign.
actually format is there, but I have a name. That is the format.
But it is not countersign. What is this resolution MOM?
Counseling, we have to submit this annexure 6 from case 16. There is no countersign by them. They are now saying that the student organization has various form. Case 16 is the format, my lord. The issuance of the certificate deputy commissioner, we have to obtain countersign signature from the director member.
All right, third, counsel for parties on permitting the learned government advocate to obtain instructions with regard to the grievance of the petitioner regarding the non-issuance of the caste certificate with due counter signature by the director. Countersign to be made by the director, T Welfare, Government of Assam. The learned government advocate has placed before the court, has submitted before the court that on the basis of certain objections raised by the Assam Tea Tribe Students Association, City Branch Committee, ID their letter number so-and-so dated 17/7/2025, that the petitioner does not belong to the tea garden labor / ex-tea garden labor community. And therefore, her case be investigated and the caste certificate issued be cancelled. Stop. In view of such objections raised, the Director, Tea Tribes and Adivasi Welfare has called for a verification report from the President Sa Janajati Jatiyo Sonnmilan Assam, as well as the Chairman State Level Caste Security Committee, Social Justice and Empowerment Department, for re-verification of the caste status of the said candidate. Stop. Learned Counsel submits that this verification, upon completion of this verification, it can be determined whether the caste certificate issued to the petitioner was correctly issued and is required to be countersigned by the director, Tea Tribes and Adivasi Welfare, Government of Assam. Stop. There are Mr. Gogoi and the other end submits that the petitioner has successfully cleared the NEET examination and is awaiting her admission pursuant to the counseling process, which is likely to be initiated within the course of this week. Stop. As she has submitted her papers to claim the benefit of the Tea Tribes quota on the basis of the caste certificate, on the basis of the certificate issued by the competent authority, she should be permitted to partake in the process of the counseling, which is scheduled in the course of this week. Stop. Considering the submissions made, this court is of the view that this matter will require consideration. Therefore, at this stage, notice be issued, returnable 4 weeks. The respondents are represented by MS S. Borwa, representing the respondent number 3, Mr. D. Upamanyu, respondent 1, 2, and 4. Stop. Since the respondents are represented by the respective counsel, notices are waived, extra copies will be furnished within a period of 1 week from today. Meanwhile, the petitioner will be permitted to participate in the ensuing counseling scheduled to be held by the under the Directorate of Medical Education, as the chairman. However, her admission will be subject to further orders of this court. List accordingly.
Item 11.
Yes, Mr. Raman.
Retired from service was not government. A private professional course, that's included options. And subsequently, the expert on section 7 5. But we look, I am really correct, will add in mind. I do not know how to read and how to write. Problem is rising by lot, my name was not exalted in this sanction table. So my. But the data of the judgment, I have not been paid using no things sanctions and be sanctioned.
Whose name is inserted?
And
Well, who's for the railways? Notice will have to go. Let the standing council appear. Heard council for parties issued notice, Mr. Rahman for the petitioner. You are SSA. Yes. Rahman, appearing for the petitioner. MS S. Borua 4. Respondent 1. It is represented by railways. You are appearing. Oh, okay. Appearing for all the respondents. Stop. Issue notice, returnable 4 weeks. Steps. Since the respondents are represented, notices are waived. Extra copies will be furnished within a period of 1 week from today. Notice also on the interim prayer. Returnable after 4 weeks. Matter be listed on a date to be fixed by the registry. Second.
Item 12.
Some similar. These parts are part of it. So my. There's a portrait order about those who are. These people is pending, those, if those 2025. This is, yes, is pending, if we appreciate it pending. It's not covered.
All right. We'll issue notice here. That council for parties issue notice returnable 4 weeks. Mr. T.C. Sutia appears for respondent 1 and 2. And who's for PWD? You are appearing for 3 also. 3 is chief engineer. So in our copy, it is chief engineer. Who's for PWD? Mr. Nayak. Mr. P. Nayak appears for respondent number 3. H. Borua on behalf of P. Nayak. Since the respondents are represented, notices are waived. Extra copies will be furnished within a period of 1 week from today. List after the returnable date.
Item 13.
Consequent time, based on 41 extra time. Simply consequent. Let's submit a proposal to joint secretary. For appointment of the petitioner, may I be?
Let him obtain instructions here. Yes. Heard counsel for parties, Mr. J.K. Goswami representing 2, 6, 7, and 8. We'll obtain instructions. 2, 6, 7, and 8. Mr. J. Hendick appears for the Revenue Department. Have you been served with a copy, Mr. Hendick? You have received a copy. We'll obtain instructions in the matter with regard to the claims made by the petitioner. Mr. A. Fukan for 1, 2, and 3. 1, 2. 1, 1. Mr. J.K. Goswami for respondent number 2 and 2, 6, 7, and 8. Mr. J. Hendick for 3, 4, 5, and 3, 4, and 5. Goswami for 9 also. Let the respondents complete their instructions in the matter and file necessary affidavit, if so advised. Now, only for instructions at issue, notice the NI. You get your instructions. We are not issuing notice, but extra copies we serve within 1 week. Yes, Mr. Mukta.
That's mine. Already they have to create my own service. Their service period, there are 2 drives where they are for regularization. On each drive, they are named where they are better, but somehow they are named where chalk smile. So last election, we can just email what they are doing now. But only these sponsors will get chalk smile, except when nobody gets chalk smile.
This 5 persons. 37.
They'll have 4 and 5. Retired. We have retired. But what they say in the bottom line, it is certified that the above mentioned 5 number of workers have fulfilled the following 4 conditions. They have been working continuously for 10 years more. They have not been full physical. And then next one, they have been engaged in the sanctions second post. They have qualification goals. No more employees. Only things are no more employees fulfilling the above 3 conditions are left to be considered after this one-time exercise. So only we were left out somehow because of some. So at least they will issue notice marriage.
Yes.
I am paying for pension only, madam.
Heard counsel for parties issue notice. Returnable 4 weeks. Mr. Vasamatari appears for Musari appears for respondent 4, 6. And Mr. A. Chakraborty for the respondent 3, H. Borua for public health. Appears for respondent number 2. Who's for public health? MS. M. Kolita for respondent number 1. Then 1 and 5. And 6. 1, 5, and 6. Okay. 4 and 6, Musahari. And 1 and 5, Kolita. Then 2, Borua. 3, Mr. Chakraborty. Since the council represents the respondents, notices are waived. Extra copies be furnished within a period of 1 week from today. List accordingly. 4 weeks.
Item 15.
What is the major penalty? Dismissal. Compulsory retirement. Any appeals filed? We'll examine that. At this stage, notice. All right. Heard counsel for parties issue notice written about 3 weeks. Mr. B. Chakraborty appears for all. Appears for 1, 2, 3, 4. MS so appears for respondent 5 and 6. The respondents being represented by counsel for parties, notices are waived, extra copies we furnished within a period of 1 week from today. In view of the objections raised regarding the question of maintainability, the same is kept open to be on territorial and alternative remedy. These issues will be addressed at the time of admission hearing. Are you challenging the office memorandum? Heard counsel for parties issued notice written about 4 weeks. The respondents are represented by Mr. T.C. Sutia, being respondents 1, 2, and 3. Mr. 1, 2, 3, and 5. 1, 2, 3, and 5. Circle officer, sub-registrar. Mr. Hendick appears for respondent 4. As the respondents are represented by the respective counsel, notices are waived, extra copies be furnished within a period of 1 week from today. List after the returnable date.
The 17.
Get your instructions here. Friday. Get your instructions. Why the representation has not been disposed of for this small matter? Why are you forcing people to come to court? Respondent counsel representing the Forest Department will obtain instructions as to the status of the representation stated to have been filed by the petitioner. On which date? Page number? On 11/4/2025, within bracket annexure 10 to the writ petition. Before the respondent number 6. Let these instructions be placed before the court on 22nd, 27th. Mr. Dotto, you're appearing for APSC. Mr. Dotto appears for APSC. Yes.
18.
Yes, Mr. Chaudhary.
20. Exceeding manner, the discharge order of 21st July 2025. Well, if I may just give the notice of that, notice they keep the file department. This petitioner matter in item 18, 20, and 21, 15 batch of ACS office. 19 and item 19 and item 20, the petitioners of 2015 and 18, 20, and 21 are 2016 batch. Now, they joined the service as a probationer in 2016, 2017. Now, they complete, well, the period of probation is 2 years. They are given regular posting. These appointments are against the substantive post in the regular appointment and is a sanctioned post. So what happens is this man. One Dibrugarh PS case is registered in 2016. These big petitioners are implicated in the supplementary charge sheets filed later. They are not released. There's nothing you can claim in the FIR. So they were initially suspended, and that was followed by a discharge order of 2019, insofar as the petition item 18 is concerned. These discharge orders, are the subject matter of challenge before this honorable court in a writ petition. The single judge, Justice Manojit Bhoya, has the lordship then by a detailed judgment, of 18th March 2020, dismisses the writ, holding that our contentions were dismissed, that as an officer of the state civil service, we are entitled to the protection under Article 311 code. Namely, that there has to be a proper departmental inquiry by a so-called court. These discharge orders are without any inquiry. It's an abrupt order. These are unilateral orders. So our contention before the single judge was that these discharge orders are stigmatic and punitive. The lordship knows, that even 311(2) protection is available even to temporary and probationers. But for temporary and probationers, to get the benefit under Article 311(2), the law is settled by the Constitution Bench in Purushottam Law Dera 58, followed by our Motiram Dekha, 7 judges bench. Then Samshed Singh, Justice Krishna, says that if the order is stigmatic, if it is punitive, then 311(2) protection is available. Officer. Single judge holds as a finding of fact that these allegations pertain to pre-recruitment, saying that you entered the service by committing this illegality, namely there was some hanky-panky in the examination process. The single judge carves out an exception to 311(2) to say that pre-recruitment anomalies will not fall within the definition of misconduct and unjustified services. So single judge dismisses all the inquiries. We come up with a field, I had the occasion to appear for one of the appellant before the division bench headed by Justice Suraj. The division bench on 20th June 2025 passes a detailed judgment. It's an emphatic order. The division bench holds as a finding of fact that these discharge orders of all the appellants are stigmatic and they are punitive. First, division bench holds as a finding of fact and is a finding of law that all these officers are entitled to the protection under Article 311(2), relying on Motiram Dekha, relies on a single judge bench judgment of Justice Surana, that I have also said that even for probationers, this protection is available under 311(2). Division bench as a finding of fact holds, the lordship knows under 311(2) second provision. If the government feels that it is impracticable to hold the inquiry, then it can dispense with the inquiry. So division bench holds as a finding of fact that there is no order of the government dispensing with the inquiry under 311(2) second provision. Division bench holds, that no law has been placed on record which would enable the court to hold that the dispensation of inquiry under 311(2) second provision is not required. Division bench holds, as a finding of fact that all these appellants, I'm stressing on the word appellants because there were a total of 49 appellants before the court. All these appellants were treated as regular as confirmed by court. Division bench holds, is a finding of fact that the period of probation, except Assam Police Service rules, is 2 years, which is extendable by a period of 2 years by the proviso. Division bench holds as a finding of fact that all these appellants had completed the period of probation. Now, the division bench, the directions which it passes, says that A, we set aside the judgment of the single court. This is mere judgment is set aside. Appeals are partly allowed. And in paragraph 140-1, the court says all the appellants stands reinstated in service, subject to the following. So the first distinction, first direction of the clause at 141 is the court says is that the discharge orders are set aside. Appellants, then the court said in 2, the appellants who have completed the initial period of 2 years and by taking into consideration the maximum period of probation, are liable to be reinstated. Number 3 says, for those appellants whose period of probation has not been completed, then the government can pass necessary orders based on the observations made by this court. 5 holds, there are 2 notifications which are found to be backdated, where police officer and held to be void ab initio. And 7 says, if there paragraph 147 says that in case there are any appellants who have not completed the period of probation, then the government can pass the order. Now, what the government does, just next straight away.
Let us understand the directions at 140.
Yeah.
141(1) says that 2 years extendable, they are liable to be reinstated.
Yes,
Then number 2, whose periods have not been completed.
First one, permit me to read it with this.
Yes, yes.
Those appellants who have completed the initial period of 2 years, and by taking into consideration the maximum extendable probation period under their respective service rules, are liable to be reinstated within the period. Well, if you have completed 2 years of probation, you're liable to be reinstated.
Yeah.
2, for those appellants whose period of probation has not been completed, by taking into consideration the initial probation period and the maximum extendable probation period under the respective service rules referred herein above, the competent authorities are directed to pass orders, appropriate orders, as may be deemed fit and appropriate, considering the findings rendered in the judgment and order, as well as by
So these categories are not required to be reinstated.
Who said, in terms of the findings and directions issued by this in this judgment,
Hmm.
the findings are that the discharge order is stigmatic and punitive. So which means what? They are entitled to the protection under 311(2). Now please see 3. The notifications dated 2012, 17 and 2/21, 18. These were notifications pertaining to the police service officers whose their probation was thought to be extended. Court found as a matter of fact,
Those are interfered with.
the court said these are very surprising. These are created documents. Court rendered a finding that these are suspicious documents, so court declares it void ab initio. Right, madam? Now, please see, it is clarified. Then please see 4 minutes. It is clarified that this judgment and order shall not come in the way of the competent authorities in the government to initiate department proceedings against the appellant in such way and manner as they may be so advised. However, the state respondent should make an endeavor to complete the departmental proceedings within a outer limit of 90 days from date of restatement. So, what does the court say? You can proceed with departmental proceedings. Now, 5. For the period of the appellants were not in service, that is from the date of discharge to the date of restatement, the appellant would not be entitled to any back. However, the monetary benefits for the said period shall be calculated notionally for the purpose of taxation benefit, etc., and for calculating the time space of the date of reinstated in service. 6. It would be open to the competent authority in the government to keep the appellants without any posting till the departmental inquiry proceedings, if any instituted against them, are brought to its logical conclusion. And alternatively, it would also be open to the competent authorities to post the appellants at such case from where they will not be able to influence the witnesses in the trial procedure. Now, please have 7 minutes. If if there are any appellants whose probation period has not been completed, they would not become entitled to be reinstated in service. However, in respect of the competent authority to bring the government, to withdraw the respective discharge orders already passed, and to substitute the said discharge order, it is simply the discharge order not found.
Is there any occasion to withdraw it? Because you've already set aside.
What's the thing?
No.
If there are any appeals, court has not identified any of the appeals. If there are any appeals whose probation period has not been completed, so my respectful submission is different. 7 will apply to a case whose probation period is below 2 years. This 2 years is the period extendable by 2 years.
So either below 2 years or below 4 years, as the case may be.
Yeah.
Ah. That there are no extensions. All right. And there were no extensions.
Everyone out of 49 minutes, I am told as I address your lordship, 47 I wanted to get discharged. Who falls in category 1, 2, 3, 4 minutes?
Hmm.
They have minutes turned the judgment upside down. And I'm sorry to say, minutes, the state has acted in a very vindictive manner, minutes. The order minutes and my respectful submission flies on the face of this judgment. It's an illegal, arbitrary, whimsical order minutes. And in my respectful submission, whether this order needs to be stayed. Now, please see the findings.
What is the effect of 141?
Wait a minute.
Paragraph-
141. The implementation of this order shall remain in abeyance for a period of 30 days from date of this order, thereby giving the state a window of such time. So says, judgment is stayed for 30 days. Needful would be either you go to the Supreme Court, or in the meanwhile, you put your house in order, you issue notices to them, start the departmental proceedings. All this will take some time. So for 30 days,
No SLPs.
no SLs. My clients, my lords, are on caveat waiting in the Supreme Court. And the discharge order is passed. Now please have the discharge order at page 62. Something very serious. I don't understand how the such power. First time, whether I'm noticing whether the state has acted, has brazenly violated the judgment of this court. Here, parties here.
So why are you not before the court in contempt, filing contempt?
Yeah, there is an order which has been passed.
Hmm.
There is an order.
Discharging you. Right.
Please have page 62.
Yes.
Whereas,
Yeah.
in compliance of, okay, have that one.
Just a minute. Please. Yes.
Whereas in compliance of the directions at paragraph 141, will mark minutes. 2 read with paragraph 141 said. Passed by the Honorable Guwahati High Court dated 20th June 2025 and other linked cases, the Governor of Assam is pleased to withdraw the government's order of discharging payment in Bazunda. This order has been declared to be punitive, it is stigmatic. And whereas
No. What we want to know is what was set aside by the court? The judgment? All the discharge orders. So where's the occasion to withdraw? It's already set aside. Hmm.
this discharge order is taken punitive. If it is
That's all right, but stay. All right, that
directed by the Honorable Guwahati High Court, the case of Moon Mazumdar, that's the petitioner in academy, who was on probation in Assam Civil Service at the time of discharge, dated 2/1/19. Well, my probation period was completed on 18/10/18. Just mark that 18/10/18. I completed 2 years. There is no extension. As is considered, and upon consideration, she is not found fit for confirmation. I pause here for a moment, madam. You are considering it. You are taking an action by the detriment of a citizen. And then see, madam, now therefore, this, madam, is also unilateral, madam. On plain elementary principles of law, madam, your lordship will have to set aside. So this is a completely ex parte order. Now see, madam, now therefore, the Governor of Assam, in exercise of powers conferred under 20C of the Assam Civil Service Rules, is pleased to discharge limiting the central service effective from 2/1. That is the date of discharge by notification number so which stands substituted with the direction of the order. And I pause here for a moment. Moment they refer to this notification of 2/1/19. Look, this 2/1/19 notification is stigmatic and punitive. So this order also is stigmatic and punitive moment you refer to them. And when the test is, Mela, will it impact her future employment? Answer is yes. Who will take this officer in employment, ma'am? Now, let's please have, Mela, straight away the findings of the division bench. Well, the division bench, Mela, the lordship will first have at para 67, page 277. At page para 54, page 267. Tells out the rule. The officer will have the rule.
50, Which paragraph?
54, page 267. I know that.
Yes.
Some civil service rules will not be present. Yes, by the first 20, a member shall be liable to be discharged from service. C, because action is under 20C, if any information will be received relating to his integrity, age, health, character, and antecedent, the governor is satisfied that the probationer is ineligible or otherwise unfit for being a member of the service. So I asked myself, page 62, whether this record that I am and there's anything on my integrity, age, health, character, or antecedent.
Yes.
Secondly, my lord, please, just by as a proposition of law, my lord, 20C, my lord, said,
Hmm.
if any information is received, right, my lord, relating to his integrity, age, health, character, and antecedent, the governor is satisfied, the lord said that. So, my lord, this satisfaction of the governor, my lord, cannot be ex parte. Law is, my lord, that the principles of natural justice will have to be read into 20C.
Where is the finding of the division bench that even for provisioners, you'll have to issue a notice? Is there a finding?
Yes, yes. Page 2305, para 111.
Yes. Yes.
And read from 304 minutes.
Yes.
Therefore, para 110.
Yes.
Even if for the time being, the contention of the learned counsel, senior counsel for the state is accepted that the discharge orders of the appellants are innocuous. Those were 3-line discharge orders. Yet, the contents of the office file, which has been produced before the learned single judge and referred to the impugned judgment, makes it clear that the contents of the office file constituted the foundation to discharge the appellant and not the motive. Therefore, on lifting the veil, the observations made by the learned single judge in para 43 to 48 of the impugned judgment leads to only one conclusion, that the state government at the highest level has arrived at the conclusion that the appellants had secured jobs diligently on the basis of colossal fraud. There can be no other conclusion that the same formed the foundation to discharge. But now please have 111 minutes. Therefore, even assuming that the appellants were professionals, yet when the discharge order is based on foundational facts and the materials available against them was not the motive to pass discharge order against the appellants are found entitled to the protection envisaged under Article 311. Okay. So this finding matter is again reiterated matter, and the lordship will just say. Page 316, para 125.
Yes.
In the case of Commodore Commanding Pointo versus Rajan 1981 to 8636, the Supreme Court of India had expressed its agreement to the reinstatement of the Kerala High Court. The respondent was only a temporary government servant, and that even as a temporary government servant is entitled to the protection of the period of the Constitution, where termination involves stigma or announced punishment. And Justice Surana refers to a single bench judgment of 19 and said that this is how we get interfered with. Now, please have page 318, para 120.
$129.
129, page 3.
Yes.
I'm reading 6 lines from the top. It is reiterated.
Yes.
It is reiterated that in this case, on the perusal of record, learned single judge found complicity of the appellant in a colossal fraud. Therefore, in the present case, the service of the appellant was terminated as a measure of punishment. So I'm entitled to 311. Then please read further.
Not by way of simpliciter.
Yes.
Discharge.
Yes. Now please have the finding that 138, because 140 will have to be read in 138.
Yes.
Also at 320 minutes. 320 minutes.
320.
is part of paragraph just about 134,
Hmm.
3 lines. However, in the said case, the one case is distinguished by the division bench, the office has the sentence manner. Last sentence of para 133.
Yes.
However, in the said case, the issue raised did not involve the protection of Article 311 for the content to which the present appellants are found entitled to. Because the court says, I'm entitled to, as a matter of fact, in a matter of law, the Article 311 protection is available.
Yes.
And now please have para 138. This is something which the state government has completely overlooked. I read para 138. In the light of the discussions about the court is inclined to hold as follows. Number one, the finding of the learned single judge internally holding that the appellants to be involved in securing job by unlawful means in collusion with the then chairman of the APSC. In collusion, that other arrested members of the APSC and officers and agents connected therewith are based on the grounds of arrest of the measures collected even the prisoner, which are contained in the office files covering all the 50 petitioners, which indicates existence of materials which are foundation for discharging the appellant, and those foundational facts have been brought on record by calling for the detailed report for the Dibrugarh police for further taking further action. Under such circumstances, without disputing the stand of the state respondents, that the discharge orders, despite referring to suspension in some cases and arrest and suspension in a few cases, are not stigmatic. It is open to the court to lift the veil to find out whether the discharge order is simplicity discharge or is it punitive and stigmatic. Therefore, the finding of the learned single judge that the appellants had secured employment as professionals due to colossal fraud, the discarding of misconduct as per pre-recruitment phenomenon is found to be contrary to the requirement of Article 311 of the law. So it was Justice Muyamela rejected our case under 311(2). Now, let us please see to the findings of the learned single judge in accepting the statements made by 28 of the 52 petitioners, purportedly admitting their complicity in the illegal activity to which they were benefited, had failed to consider true legal. This, my lord, is on the aspect that there were some alleged confessional statements which are placed in a sealed cover before a single judge. Division bench says, my lord, that these confessional statements are not admissible in view of 25, 26 of the Indian Evidence Act, and court could not have relied upon. Now, let's see 3 minutes. The learned single judge had failed to appreciate that the competent authority of the state government had not passed any order as envisaged under proviso B, the second proviso of Article 311(2), which requires that when the authority empowered to dismiss or remove a person or reduce him in rank is satisfied that for some reason to be recorded by the authority is not reasonably practical to hold that, which vitiates the improved judgment and all. So it was not dispensed with. Now, please see minus 4. Paragraph 4 holds that the action of the state suffers from hostile discrimination. There were 3 approvers, minus, who were not discharged. Against them, minus, 311(2) protection was given. So, division bench find, minus, the office will see, minus, such discrimination is not found supported by any law or approved by any judicial pronouncement of a constitutional court. Therefore, the discriminatory process against the appellants having have not been taken into consideration by learned is also found to have vitiated the improved judgment. Now, 5 minutes. As the reasons to terminate the appellant, according to the improved judgment, is the participation of the appellant in colossal fraud. The learned single justice mark had failed to take into consideration that the service of the appellants, though projected to be probational, in substance represents a penalty imposed on the appellant and or punitive action taken against them. And such an action has been held by the Supreme Court in para 13 of the case in Motiram Data, decided by special bench of 7 judges to attract Article 311(2) for the termination removal. Moreover, it is further held that Article 311(2) makes no distinction, please mark that, between temporary and permanent court. The same is found to vitiate the improved judgment. And 6, the learned single judge had failed to consider the relevant provisions of confirmation of a probation as laid down in the respective permissions for the appellant. Because, please mark, except the Assam Police Service, all other applicable service rules envisages a probation period of 2 years, extendable as provided therein. And therefore, at the time when the appellants were discharged from service, they had completed their normal tenure of probation. Please mark this. Therefore, the appropriate government will have to take a decision. Please mark this line, in terms of the applicable service rules as to which of the affiliates have not completed. I pause here for a moment, madam. The decision at page 62 does not record this. There is no decision taken by the government as to which of the officers have not completed the 2-year probation. All these petitioners has completed 2 years. Now please see 7. Although in para 42 of the improved judgment, it has been noted that if the termination from service is not to be founded on misconduct, negligence, inefficiency, or other disqualification, then it is a punishment, and the requirements of Article 311 must be complied with. And further observing that where the form of the order is just a facade of dismissal for misconduct, justice would require the court for which the order is put to challenge to go behind the form to ascertain the true characters of the order. However, the learned single judges fail to appreciate that in these cases, the investigation report in Dibrugarh, please mark this one, was a live link to the order of discharge, and therefore the investigation report and motive was a discharge. Number 8. In paragraph 45 of the interim judgment, it has been mentioned that in the office file for all the petitions, the case given there was a chronological record of information of the events which had taken place following information received from Dibrugarh PS case as regards the appealant in connection with Dibrugarh PS case, including decision calling for detailed reports by Dibrugarh police on taking further action, receiving of such reports in connection with the rest of its petitioners to withdraw the services of the service of the service pending action to be taken by the personnel department, to obtaining reviews of the views of the judicial department before taking the final decision, and to obtaining the approval according to the minister of the state, together with the views of the Advocate General before they were discharged from service of the governor, which is a clear indication, please mark it, that those were the motive to discharge the villain and were not the foundation to discharge the action. As such, the finding at para 48 of the interim judgment, holding that the interim order is based on foundational facts emanating from reports of the Dibrugarh police is not sustainable. Nonetheless, the procedure adopted by the learned single judge to peruse office file without any disclosure, but this is reliance on seal cover. Records court came down severely, relying on Supreme Court judgment. The seal cover document should not be relied on. And 9. In the light of various decisions of the Supreme Court has discussed about, wedding has been here, please mark this part. Protection of Article 311(2) was available also to a probationer. And in the light of the fact that nothing was placed on record to show that authorities had passed any specific order as required under clause 3 of the second proviso of Article 311(2), the reliance on the decision of the Supreme Court in Palak Modi, Parasuttam Lal Bhingra and Samsay Singh is not sustainable. Article 311, please mark it, does not create any distinction between a confirmed regular member of service and a probationer. And 10. The finding at paragraph 49 of the interim judgment that the arguments to the effect of the provision of Article 311 do not require to be gone into, where the foundational facts as revealed by the police reports are duly taken into consideration, is also not sustainable in the case of Inderpreet Singh Kellam was wrongly applied. Now, please now come to the direction therein without again. Because even I was at loss. I was wondering, did I miss something? Because the state's action seems to be that the judgment has been, that the appeal has been dispensed. Only 147 exists. Because I had to read the judgment at least 5 times. Did I miss something? Is there something wrong that we are not understanding? Now, please have 148. Accordingly, the appeal is partly allowed by setting aside the interim judgment. So, the judgment is satisfied. 1. The discharge orders in respect of all the appellants herein are set aside. So, the discharge orders of 2019 set aside. Now, they are reiterating it, and saying in substitution of that, we are now giving. Now, please see what subject to following. I'll read again, because the losses also must be wondering. There must be something to this madness.
We spent the whole evening wondering that yesterday. But anyway, let us see what happens. Yes. Are you completed or? Yeah.
The division bench will hold as a matter of fact. Just one finding I will render, I'll take a lot of is that page 273 the lot is come. Let's see how meticulously the division bench got before. See the issue at page 270, just above 58. Where on whether the period of probation of the appellant was over when they were discharged. Let's please see the findings here. First, para 67 is 270. Issue is whether that period of probation was over when they were discharged. Please see 67. If the submissions made on behalf of the state is accepted while dealing with the appellant, the competent authority of the state appear to have made several mistakes. Number one, if it can be called granting second pay increment which requires bills to be prepared, scrutinized by the Office of the Accountant General and concerned treasury before higher pay is released. 2. Allowing taking over of charge for the appellants as professionals by handing over next charge to them without referring to them as professionals. 3. Transferring the appellants as a regular member of the service to different departmental officers. This, in the considered opinion of the court, is not likely to happen unless the government was not treating the appellants as a regular member of the. Now, please read the next sentence. It is not the projection of the state respondent that some inadvertent mistake had happened, which is unlikely, as several officers of the applicant government must have handled the service record. Now, the next 68. In the aforesaid context, while the presumption is available on 114, now 119, that is that all judicial and official acts are regularly performed by the said provision of law, while it can be accepted that on granting second pay increment by giving regular posting and on being transferring to department officers, the positions of the appellants had been altered. Please mark that, madam. From the status of probationers to the status of a regular employee in the absence of any other position.
Sorry.
It cannot be presumed that the status of the appellant remained as probationer. Now, how does the improved orders understand what is after this finding? Now, see the next finding. Para 74.
Yes.
What is that? There's a reference to G. Ramaswamy last sentence. They are merely excelling the discharge orders from service. It is not. And by the conduct of the government, the appellants have been able to demonstrate that they were being treated by the government as not government. Now, para 75 also.
All right, let us hear the respondents. Yes.
I say, my lord.
So according to you, that when the judgments have, petitions have been allowed, discharge orders been interfered with,
Been held by
you have completed. Right.
Behold that court said, even as a probationer, as a temporary servant, you are entitled to the protection that 311. Proof.
Is it your submission that in view of the setting aside of the discharge orders, there is a specific direction by the court
Yeah.
that you should be reinstated first?
Yes. First, I should be reinstated.
Where is that direction again?
Just come back again.
140. 1-1.
1. The appellant who have completed the initial probation period of 2 years.
So there was no reinstatement. There was no reinstatement. No. In your case, in spite of the specific direction, no reinstatement.
So, my respectful submission is this matter. That the judgment of the division bench is clear, categorical, and emphatic. Courts have held, my lords, on as a finding of fact that all these appellants have been treated as regular employees. Court has held, my lords, as a finding of fact that all these employees are entitled to the protection under 311 proof. The court has held as a finding of fact that the discharge orders of all the appellants are punitive and stigmatic, and hence, my lords, entitled to the protection under 311 proof. Court has held as a finding of fact that their dispensation of inquiry under 311 second proviso was not there. Court has held, my lord, that no law has been placed to say that who are probationers, this dispensation is not required to be taken. Secondly, my lords, what the court has held, my lord, is that the discharge orders are bad. Discharge order, let us say. Right, my lord? I had to be reinstated in service. And moment it is stigmatic and punitive, what the court says is to take action in accordance with law. The accordance with law means, my lord, in my respectful submission,
311.
is 11 under inquiry under 311. And most importantly, my lord, that's why I'm saying, my lord, as a student of law, my lord, that this order, my lord, is a tolerable exercise of power. It's a whimsical order by a very vindictive government, my lord, who has, my lord, completely nullifies the judgment of this court. This order, my lord, flies on the face of the judgment of the division bench. This order, my lord, with due respect, is a direct affront to the authority and majesty of this court. manner, it undermines the rule of law. So my respectful submission is, madam, this order is.
All right. Yes, Mr. Nath.
The teacher's order is very specific, but this is issued in context with the paragraph 140, 142, and the 140. And what if when it comes to 147?
Let us come to 141. 327. Yes.
One, the whole court has not said that those evidence of whose period of probation have not been completed by taking into consideration the initial probation period and the maximum expellable period, probation period under the respective service rules referred wherever carrying before taking back of the rules of the program. The competitive authorities are directed to pass such appropriate orders as to be an appropriate considering the finding environmental statement and orders, as well as the taking into account all relation factors that have been considered. This assurance can be done by the competent authorities, with respect to the department, that kindly come to 7, Roman 7.
Yes. It's 24 no material. Not.
If there are any appellants whose probation periods have not been completed, they could not become entitled to the reinstatement service. So if the authority comes to a and if the probation is not complete, then they will not become.
What would be the effect? What would be the effect of the direction of the court in 140 para 1? No. 1. Numerical 1. No, first, let us read.
Would have been assumed in the decision.
Then what is the effect of that? If they are set aside, then what happens? Set aside. So what will be their position?
If there are the appellants whose probation period has not been completed, they would not become entitled to the reinstatement service other in respect of those appellants.
You are saying that in respect of the present petitioner, provision period was not complete. No, petitioner was appointed as what? In which service? Civil service. That's for 2 years. Was it extended? No, extendable, but was it extended? Very well. Take.
Already passed and to complete the discharge orders with a significant discharge order of more than 100 feet for confirmation so that no statement of the tax is that. So they are directed to resolve by the
Not direction, the orders were set aside. This is set aside. Where is the scope to withdraw it? It's already set aside. Non-existent. No, direction of the division means is not to withdraw it. You have to read the direction, all the directions starting from which paragraph? 138 onwards. These are the findings. 138 is the finding. All right, we'll issue notice at this stage. Heard Mr. Arunab Chaudhary, Learned Senior Counsel, assisted by MSB Chaudhary, Learned Counsel for the petitioner, Mr. D. Nath, additional Senior Government Advocate, appearing for the respondents. The petitioner in this matter is aggrieved by the discharge order dated 21/07/2025, whereby the petitioner was, whereby the department was, respondents had discharged the petitioner from service with effect from 2/1/2019. Stop. The Learned Senior Counsel for the petitioner submits that the petitioner was initially appointed as a probationer under the Assam Civil Service pursuant to her selection and appointment undertaken by the APSC for the batch of so-and-so, whatever batch it was, 2016 batch. Stop. Pursuant to an FIR lodged before the Dibrugarh police station, which came to be registered as Dibrugarh PS number 936 of 2016. Investigations followed, and thereafter the government came to a conclusion that the petitioner could not be retained in service, and thereafter issued the discharge order. Is it available here? 196. Discharge order by order dated 2nd of January 2019. Stop. It is submitted that initially the petitioner was placed under suspension and subsequently the petitioner was discharged. Similar actions were taken against several probationers who were employed across various services of the state, including the Assam Civil Service, Assam Police Service, and Forest also. No, excise, transport, excise, etc., taxation, etc. The various probationers were discharged from service. Being aggrieved, approached his court by filing the respective writ petitions, and a coordinate bench by judgment and order dated 18/3/2020 dismissed the writ petitions, being WPC 4198 of 2019 and other 48 connected writ petitions. Stop. The writ petition filed by the petitioner also came to be dismissed by the said common judgment and order. Stop. Subsequently, being aggrieved, writ appeals were filed before this court. The writ appeal filed by the petitioner is writ appeal number 58/21. All right. Writ appeal 58 of 2021. Stop. Similar other writ appeals were filed by the aggrieved employees of the state. Aggrieved probationers were discharged. Stop. By a common judgment and order dated 20/06/2025. A division bench of this court, upon examining the entire matter in great detail, allowed the writ appeals in part by interfering with and setting aside the judgment and order dated 18/3/2020, passed by the coordinate bench in WPC number so-and-so, so-and-so. Stop. Para, Learned Senior Counsel, appearing for the petitioner, strenuously submits before this court that upon a careful perusal of the judgment rendered by the division bench more particularly the findings and the consequential directions issued. The impugned order of discharge issued by the respondent authorities have been issued in total contravention of the directions. Stop. The learned senior counsel submits that the division bench, upon detailed examination of the facts and circumstances and the records placed before the court, came to a finding that the discharge orders were not discharge within quotes discharge simpliciter, but rather these are orders which are stigmatic and bound to have consequences, and punitive and bound to have civil consequences on the probationers. Stop. The learned senior counsel has referred to the various paragraphs rendered in the division bench judgment as to the findings and the conclusions of the division bench, to submit that the court ultimately rendered a finding that on the basis of the materials available, as these orders were not considered to be discharge simpliciter and were found to be stigmatic and punitive, the probationers were entitled to be given the benefit and the protection under 311(2) of the Constitution of India. Stop. The learned senior counsel further submits that while allowing the writ petition, certain directions have been laid down by the division bench at para 140 of the judgment. Stop. These directions clearly reveal that the discharge orders of the appellants, including that of the writ petitioner, have been interfered with and set aside. Stop. The writ appellant, having completed the period of 2 years, was required to be reinstated in service in terms of the said direction, and thereafter the authorities were given liberty to proceed accordingly as per the provision of law. Stop. However, these directions were completely overturned by the respondent authorities for reasons best known, and the impugned discharge order has been issued, which has the effect of replacing the earlier discharge order dated so-and-so, which could not have been done inter alia on the ground that these earlier discharge orders stood interfered with and set aside by a specific direction of the court. Stop. The petitioners, the appellant, was never reinstated in service as has been directed by this court, and on the contrary, the said discharge order was the impugned discharge order has been passed without issuing any notice to the petitioner, giving her an opportunity to rebut the allegations made against her for the discharge. Stop. These actions of the department are completely colorable and contrary to the very directions contained in the judgment and order. Stop. As per instructions, he submits that no specific appeals have been filed. Further appeals have been filed before the apex court against the said judgment and order. No review petition has been filed, nor any clarificatory applications have been filed. Stop. Therefore, on a plain reading of this judgment and the directions contained therein, the impugned discharge order could not have been issued. Stop. The learned senior counsel therefore submits that this impugned discharge order be interfered with, set aside and quashed, and the directions and the specific directions of the division bench passed in the judgment and order dated so and so should be adhered to, and the petitioner be reinstated in service. Stop. He further submits that during the pendency of the writ petition, adequate interim protection be granted. Para. Mr. D. Nath, learned senior government advocate on the other end, referring to the arguments made, submits that the government has followed the judgment and the directions given by the division bench, and it is apparent from the order of discharge which is impugned in the present writ petition. Stop. He submits that in view of the specific directions given, the government has only complied with such, and the impugned discharge order has been issued, and therefore there is no infirmity in law, or nor is the said discharge order contrary to the directions contained. Para. Counsel for the parties have been heard. The writ petition, more particularly the judgment rendered by the division bench of this court in writ appeal number so and so, and other connected appeals have been carefully perused. Upon careful perusal of the judgment, it is seen that this court, the division bench, has elaborately dealt with all the specific allegations and the averment made, as well as the law. Stop. The discussions of the division bench as rendered in para 138 are relevant for these proceedings and are therefore extracted below para 138. Stop. Para. Finally, ultimately, the writ appeals were allowed by setting aside with the impugned order, and the appellants were found to be entitled to the reliefs as detailed under para 140. Stop. The para 140 is also extracted below. Para. Having considered the judgment and the submissions made before this court, it is seen that there is a specific finding by the court on the materials available before the division bench that the discharge order which was issued to the appellants, including that of the present writ petitioner, was found to be punitive and stigmatic and is not considered to be a discharge simpliciter. Stop. There is a specific finding by the division bench that the finding of the coordinate bench that the appellants had secured employment as a probationer due to colossal fraud, discarding the division bench found that such conclusions by the coordinate bench on facts and discarding the misconduct as a pre-recruitment phenomena is found to be contrary to the requirement of Article 311(2) of the Constitution of India, and was therefore held to be unsustainable. Stop. The further finding of the division bench is that the competent authorities of the state never passed any order envisaged under Proviso B to the second proviso of Article 311(2) of the Constitution of India, that it was not reasonably practical to hold an inquiry, and therefore such actions were also found to be contrary to law. Stop. The division bench came to a finding that the coordinate bench had failed to take into consideration that the termination of the appellants, though projected to be probationers, in substance represented a penalty imposed on the appellants and obligor a punitive action was taken against them, contrary to the law laid down in Motiram Decca, reported in so-and-so by the apex court. The division bench concluded that Article 311 makes no distinction between a permanent and a temporary post. And therefore, the judgment was found to be, these conclusions of the coordinate bench were found to be contrary to the judgment of the apex court. The division bench concluded that the materials which were available and relied upon to pass the initial discharge orders were considered to be motives within courts to discharge the appellants and were not foundation within courts for discharge of the appellants. It was held by the division bench that the judgment of the coordinate bench was found to be based on foundational facts emanating from the report of the Dibrugarh police and was therefore held to be not sustainable. So, but ultimately, the division bench, although partly allowed the writ appeal, however, interfered with the judgment and order dated 18/3/2020 passed in WPC number so-and-so and other connected writ petitions. Stop all the discharge orders in respect of all the appellants therein, including that of the present petitioner, were set aside. Stop. Para. The further directions as extracted here and above of the division bench reveals that the appellants who had completed their initial probation period of 2 years and were taken into consideration the maximum extendable period were liable to be reinstated within a period of 50 days from the date of judgment and the order. Stop. Insofar as the present writ petitioner is concerned, her initial appointment was on. Do you have a copy of the order? 63.
October 2nd paragraph. Is serial number 13?
This is 30th September.
On 18/10/16.
Right.
They completed on 18/10.
Was appointed by order dated 30th of September 2016, and her appointment was in. It was mentioned therein that the appointment will be with effect from 18/10/2016. Stop. The discharge order, which was issued earlier, which led to the petitioner assailing the same before this court by filing WPC number so-and-so. Where is the earlier discharge order again? 196. Was issued on 2nd of January 2019, which clearly reveals that she had completed 2 years of probation. Stop. Under the Assam Civil Service rules, the period of probation as reflected in the rules is for 2 years or for such period as extendable by the authorities concerned. Stop. No such orders were passed by the respondent authorities extending the period of provision. Therefore, from the facts urged before this court and materials available before this court, it is apparent, it is clear that the petitioner had successfully completed a period of probation for 2 years, and 2 years at the time when she was discharged by order dated 2nd of January 2019. If a date of initial appointment is to be taken as appointment order again, page number. Was to take effect from 18/10/2016. Then her probation period as per the rules would be completed on 18/10/2018. Stop. No extension of provision orders were ever passed by the respondent authorities, and it is not disputed. Her discharge order came to be issued on 2nd January, the first order, 2nd January 2019. Stop. But under such circumstances, it is clear that the case of the petitioner will be covered under direction of the division bench rendered at para 140, then 1, numerical 1, then Roman 1. Stop. From the materials available before this court, it is clear that this direction of the court has not been followed by the respondents, and the petitioner, after her initial discharge order was interfered with and set aside by the division bench, she was not reinstated in service as directed within the period prescribed under the directions issued under para 1401 within bracket Roman 1. Stop. Accordingly, this court is of the view that this matter will require consideration. Therefore, let notice issue, returnable 4 weeks. Since Mr. D. Nath, learned senior government, represents the respondents, notices are waived, extra copies be furnished within a period of 1 week from today. Issue notice on the interim prayer, matter be listed again on 22nd, 24th. We are saying that on the materials available, you are entitled to bring on record, and no, materials available include the findings of the division bench. These are judicial findings. No, we'll keep it on 24th. We should notice on the interim prayer, list on 24th. Till the next date of listing, the impugned discharge order shall remain state. No, we are issuing notice on the interim prayer. No. You tell us when you wanted, you tell us, we'll give you. We have given, you see, you are entitled to file an appeal. We have given a detailed order explaining what is the findings of the division bench. We have recorded that. No, just answer me one question. She was discharged earlier, right? This discharge order got interfered, set aside. What was the status? What was her status? Forget about para 7. She was discharged earlier. These discharge order very categorically has been interfered with, set aside. With effect from the date of the judgment, what was her status? All right, after 1 month. Right. When was the judgment rendered? So 28th July, we'll give you 28th August. You argue if you want to argue the matter, we'll hear on the interim prayer right now. We have no difficulty, but you are not able to answer a query, pointed query made by the court after interference of the discharge order, setting aside what will be the status of that particular person.
Right. And what we have to do is to compensation. And then, para 7. And this is, we have to talk about how we will
First week of September. All right. You tell us when you want it. 3rd, 4th, 5th, whatever date you want. 5th of September. All right, 5th of September. Whether we stay it, you want us to mold the directions, we can mold it, don't give effect. Don't give effect till 5th. If it makes you happy. No. We have already passed the order. All right. Is 5th good for you, Mr. Chaudhary? 4th, all right, 4th. Issue notice returnable 4 weeks. Issue notice on the interim prayer returnable on 4th September till the next date fixed. Impugned order shall not be given effect to. We are modifying it. It's as good as staying. We have said. Shall not be given effect to. Is as good as stay.
Cases like this,
Yes. Therefore, we are giving you. But the state wants some time to respond, saying that they have followed the judgment in its entirety. My limited understanding is perhaps not. Therefore, we asked you a pointed query that what would be the status after the discharge orders were set aside. So your bowing down to the court doesn't help. We need an answer from you. All right, the time frame has ended. Time frame has ended long back. So what was the status till you issued the discharge order? The order of the division bench does not say that the tenor of the earlier order is not found acceptable and you are given liberty to issue fresh orders. It is set aside. It is set aside, the effect of which you are well aware is that the order is non-existent, as if it has never been passed. Yes, we'll request you to give us a chart showing us of all the matters regarding the initial date of
21 and 6 same day. They're joining it on the same day. So they're completed on the same day.
18.
18, 20 and 22.
All right. Then
19 and 22, madam, there's some distinction in fact.
yes.
Yeah, madam, 19 and 22, they
Hmm.
joined 31st August 15. 31st August 15, probation got over in 2017.
They're also members of civil service.
Kunal Das is APS, 19.
19 is APS.
Insofar as 19 and 22 is concerned, I must candidly point out that later on, Miller, they have shown a extension of probation. Which was allegedly passed on 27 November 17.
This is after the completion of the.
Because this was completed in August 2017, much after Miller, an order was shown, Miller, which we obviously disputed that. But because that Miller, court says even as a probationer, 311(2) is applicable. Just let's not play to it. Rest other articles can be.
Yes, you can give us a chart just for the dates.
Grateful, Miller.
Item 23.
I suppose we need not be bothered that extra copies should be furnished within the course of the day, course of the week. 4th of September. Unless you are asking for a different date. We have given an order. If you are agreed, go and appeal. Go and appeal. Go and appeal.
Very grateful for it.
Yes. Thank you.
Twenty-three.
She repaired on.
Yes, get instructions why provisional pension is not released. Yeah, let him get instructions. You want us to issue notice? Heard counsel for parties. Mr. T.C. Sutia, additional senior government advocate, representing the respondents 1, 2, 4 and 5. 3, Mr. Arbor Pujari, and Accountant General, Mr. R.K. Talukdar. Oh, you're appearing. S.K. Medi, sorry. The respondents will obtain instructions, more particularly respondents 1, 2, and 4 will obtain instructions as to why the pension / provisional pension to the writ petitioner has not been released. In order to enable the counsel for the parties to complete their instructions, extra copies be furnished within 1 week. List this matter after 2 weeks. All right, you give your copies within 2 working days. 2 working days, list on 5th September.
24.
The very first thing that thought of one of the reasons we not mentioned about, because there is proprietary estate was there. Then I found a judgment from this court which interfered with the termination order from that same meeting. So I finally should come in. The order which we have, right? The transfer order is that page 81.
I think T-board has a share here. Yes.
Because I think about the pension to the quality condition. The standard number 5 and 6, they try to snatch away and trying to asking me to disclose the technology and everything. When I complain about that, that was the issue taken by them for which they have transferred me. And the second point is that they have transferred to me a particular place where the technology that I'm dealing with is non-existent. So total everything will be off. The third point is that the service suit that followed, any 8 scale that was appointment order which speak which says that I am getting more than 16,000 as a basic pay, which itself shows that my, that is the article fine at page 31. Transfer order has to be taken approval for the chairman. But at page 81, you will find that they have given a copy to the chairman, but they have not taken any approval. The CC to the chairperson, so, and the other things, my medical grounds are there for which I challenge this transfer. There is no public interest. One is the malafide by the respondent of the final say. Next is there is no approval. Third is the place that I have been transferred to North Bengal. The research that I am doing is non-existent place where I will not be able to do it. That is, I think, around 15 I have taken. Around 15, 14, around 14 page 17. I've taken,
She's posted as what? She's appointed as what?
I trying to in page 31. Appointed as scientist B applied biotechnology.
All right then.
Just now with that one of the relation between the discharge and the director matters, because they wanted to, they wanted to ask, they asked me about the proceedings that I had taken for the mistake.
You not arrayed them as parties in by name.
You are not, as the post, as I.
No, the post is all right, but you are agreed by certain officials who are in the post.
You have not made them a part. But it has been changing, because 15 days after that. So 5 and 6 is the person, and one of the approval for the chairman is necessary.
Where, under what rules?
But you-
Chairman of?
Chairman, the board, I think. That's what to North Bengal, but the one of that power technical department is not. I'll be afraid to job.
They are governed by these service rules. Which rule? Transfer. She's in which, acha, below. Okay.
Let me get you the surrender of this.
So where do you say the approval? Perhaps it is there in the file.
Yeah, from here.
Page 81.
Doesn't say about the approval.
Where is the transfer order? 81. This is the transfer order. Yes, who's for the respondent? All right, heard Mr. P.K. Roy Chaudhary, learned counsel for the petitioner, and Mr. K. Gogoi for respondent number 1 and 3, Mr. J.K. Goswami for 2, then 4 and 5. Okay. The writ petitioner is aggrieved. Writ petitioner is a scientist of at what grade? Where is her appointment order? Dated 3rd of March 2022, whereby she was appointed as scientist hyphen capital B within bracket applied biotechnology, and her basic pay has been fixed at level 10 along with other applicable allowances and rules. Stop. The petitioner was posted in the biotechnology department. What is TRA? Tea Research Association, Toklai Tea Research Institute, Jorhat. Stop. Her period of probation was for 1 year, and she successfully completed the period of probation. Stop. The petitioner is engaged in research work and development of what is the specific work you're doing? She's carrying on specific research work.
Can I pull your work to find that working as tissue culture, tea development?
No, working is all right, but you're working in some specific area. Is carrying on her research in the tea tissue culture. Stop. It is the submission of the counsel for the petitioner that because of specific research, groundbreaking research, which the petitioner is presently carrying on, the respondents number 5 and 6 have insisted on the petitioner to disclose the specifications of the research undertaken. Stop. Counsel for the petitioner submits that all research undertaken in these kind of works are closely guarded, and until the research work is completed, AC to low, research work is completed, the process and the particulars of these research works are generally not. Oh, good detail. Research works are not disclosed. Stop. The learned counsel for the petitioner submits that there is a process for disclosure of this work, and by publication of papers, etc., as and when the research work is undertaken and completed. Stop. However, the respondent 5 and 6 have been insisting the petitioner to share particulars and details of a research work carried on. Stop. Since the petitioner resisted their requests, undue requests, the impugned order of transfer has been issued. Stop. It is the submission of the petitioner that this transfer order and impugned transfer order and posting her to North Bengal Regional R&D Center at Nagrakata in the state of West Bengal will render her efforts to continue research fruitless, as the present research facilities are not available in the center in which she is sought to be transferred with. Stop. It is submitted that this transfer order is also violative of the service rules. Stop referring to the service rules. Learned Counsel submits that this transfer order, for such transfer orders for executives of pay scales at and above 16,400-20,000, the chairman's approval is necessary. Stop. The petitioner is at a level higher than the pay scale of 16,400-20,000, and therefore the transfer order, for such transfer orders, approval of chairman is necessary as per the rules. Stop. However, the impugned transfer order does not disclose the same, and to the best of the information of the petitioner, such transfer orders, the impugned transfer order does not have the approval of the chairman, Tea Research Association. Stop. Being agreed, the present writ petition has been filed. Para. The Learned Counsel representing respondents 1, 2, 3, 4 submits that they have no administrative they are not the administrative authorities, and or are concerned with the transfer orders issued. However, it is only the respondent 4 and 5 and 6 who can apprise the court as to the requirement and the legality of the impugned transfer order issued. Stop. But the Learned Counsel, Mr. Gogoi and Mr. Goswami, does not represent respondent 5 and 6. Stop. Accordingly, let notice issue returnable 4 weeks. Since Mr. Gogoi and Goswami represents respondents 1 and 2, 3 and 4. 1, 2 and 3. And Mr. Goswami represents respondent number. You are for 2. Mr. Gogoi for 1, 3 and 4. Sorry. 1 and 3. Mr. Goswami is for respondent 2. Notices are waived in respect of these respondents. However, extra copies will be furnished within a period of 1 week from today. Steps on respondent 4, 5 and 6 by registered post AD as well as usual force within 1 week from today. Let this matter be listed again on 22nd of September. Impugned transfer order dated so and so shall remain state till the next date of listing.
Item 25.
Your prayer is for pension. Yes. Heard counsel for parties. MS Kolita, Learned Counsel representing the respondents 1, 2 and 3. Prays for some time to complete her instructions. Mr. C. Borua appears for respondent 4. Let the matter be listed after a week, by which date the respondents will complete her instructions. List on 3rd of September. Extra copies be furnished within 2 working days. You get instructions, let us see what happens.
Supplementary list for motion item 61.
Yes. Standing counsel, who's for the taxation department? Taxation department? Yes. So where are they? Please inform them we are calling up the matter at 2 p.m.
62.
Any objection? Counsel for the respondent renews a prayer for further time. Matter stands deferred to be listed after 3 weeks. MS so appears for the writ petitioner. 3 weeks.
Item 53.
We will find our affidavit.
I see. I see. No? Filed yesterday. Additional affidavit. Yes. Yes.
There been that our employee is given to the as a proposal.
Your ground is that wages do not include pension.
The beginning of the year.
Payment of wages. ID Act. Industrial disputes. Why don't you allow him to submit? You'll get your option. We'll hear you on maintainability. How can you decide on maintainability without hearing the basic facts? Take your seat, let him argue. Yes. 2 capital A. Yes.
Any dispute to difference between their selected. Any employee connected to the negative. Out of check, and exclusion. There will be the industrial. No one working for any union, but working to the one. Now, here was to find. This paper relates to transfer of an. These levels sound contaminated. And this is why second section 33. But was the solution.
This 2 capital A is an exception to section 10. So they can come directly. Then 33.
Different.
33. Yes.
Pending anything complete. No employer shall during the pendency of any such proceeding in respect of the industry must be take any action against any protected party. Now, they did not make it anything that is a protected party. Now, protected party has been defined for in the section. There should be under the new zero by the first
Yes.
Just one. That's not the.
Yes.
Protected workmen, every registered trade union connected to the industrial which the act applies shall communicate to the employer before the 30th September of the year. The name and addresses of such a professional relief for employed in that establishment and who document the union should be recognized as protected workmen. Any change in the incumbency of any separate committee by the implementing the employer shall subject to section 33 recognize as worksman for the purpose of section 3. The same section is communicate the union in writing will be to seek the names and addresses in the servant the list of protected workmen. Now, he is a protected workman. In that particular circumstance, there we get some benefit. Now, in these cases, we will find nowhere they are taking protected work. And if it is really protected workman, then the union will have to refer the name of the protected workman to the employer. And in nowhere of that section, the listing is still fine. But only 1% of the managing staff can be treated as a protected workman. There is some procedures. Now, we will have to make a fee. That means a protected workman we get.
Yes, all right.
Section.
What is your objection? Huh? Last page. Hmm. Hmm. Hmm.
And date is 30th of October 2020. If person concerned got the registration number as notary on 30th of October 2023, and how will he notarize the document of waiting and other documents 2023? As well, this is not a major document. As well, there is no proper authority and considered as not maintaining.
Yes, Mr. Doctor. You have to verify and come back. This is no. He says in page number 85, down below you find the round seal of notary. Name of the notary is there. Registration number dated. He wants to say that the person is registered only on 30/10/2023. And the execution of the document is on 3rd of August. No, 3rd. 23rd is below, but 3rd above. You have signed it on 3rd, but all right, 23rd of August. So if it is 23rd of August and he is registered in October 23, he could not have done it. Right. All right, that's true. Hmm. Wait, from where do you say that? Hmm. Hmm.
What I understand.
All right. Let us.
Number in the left, right.
No, all right. We are not getting ourselves detained on that. He'll have his objections to raise whatever objections he wants. Only because it was raised and prima facie, it did appear that the dates were, it was not clear whether he was registered or.
Council.
Ah. Have you given him a copy of this? You take it, have a look. All right, we are issuing notice at this stage. We are issuing notice at this stage. Heard, done it. Mr. S. Dotto, Senior Counsel, assisted by Mr. M. Sharma, Mr. M. Hoikia, appearing for the caveator. Petitioners are aggrieved by the order passed in Miss Case number so-and-so, dated so-and-so, by the Labour Court. Whereby, so, this was a transfer order, is it? Whereby the transfer order issued to the caveator was stayed. Stop counsel for the petitioner submits that the Labour Court does not have the jurisdiction to entertain any transfer orders, any disputes relating to transfer order in view of the specific provisions under rule under section 2 capital A, as also under section 10. It is submitted that the issues which can be looked into by the Labour Court under the Industrial Disputes Act pertains to dismissal, removal, discharge, or retrenchment. Stop. This transfer order clearly reflects that there is no dismissal, removal, discharge, or retrenchment of the petitioner. It's a mere transfer order issued by the respondent authorities on administrative exigencies. Where Mr. M. Hoikia, on the other hand, submits that there is no infirmity in the order passed by the Labour Court as well, this transfer order. Where is the impugned order? As the impugned order has been held to be an order of demotion, redesignation by the management, and therefore the Labour Court has exercised jurisdiction and passed an ad interim injunction. Whereas he further submits that his writ petition is not maintainable as the person executing the affidavit as well as the power in favor of the counsel for the petitioner is not authorized to do so under the power of attorney executed. Is not authorized to do so, referring to the power of attorney enclosed to the petition, as well as a fresh copy of the same being brought on record by filing an additional affidavit by the respondents, by the petitioners. Counsel for the caveator respondent submits that perusal of the conditions in the MOU in the power of attorney reveals that the present deponent executing the affidavit, as also the power in favor of the counsel, is not authorized to do so. Stop. The power is reposed only in respect of the chief executive officer of the company, which is clearly revealed in the power of attorney executed. Stop. Under such circumstances, he submits that no case is made out for interference with the order passed by the Labour Court. Having heard counsel for the parties and upon careful perusal of the provisions of the Industrial Disputes Act 1947, read with the impugned order, it is seen that the application, the impugned order reflects that this is an application under section 33 and 33(3)(b). Stop. A perusal of the the said sections reveals that 33 gives a protection to the workmen that during the pendency of any conciliation proceedings before the conciliator, no employee / workman shall alter or prejudice the conditions of service applicable to them immediately before the commencement of such proceedings, end of legal discharge, dispute or punish, whether by dismissal or otherwise, any workman stop. Such protection is also extended under section 33(3)(2)(b). Stop. From a recital of the facts available in the impugned order, it is seen that there is no reference that any conciliation proceedings or any other proceedings before the Labour Court or the Industrial Tribunal was pending prior to issuance of the transfer order, which the respondent, caveator, considers it to be an alteration of conditions of service to the prejudice of the workmen. Stop. That apart, under section 2(A), The Act of 1947 clearly provides that the workmen may have access to, may ventilate their grievances in respect of any orders passed by their employer in respect of discharge, dismissal, retrenchment, or termination. Stop. Under such circumstances, this court is prima facie of the view that since no materials have been placed by the caveator respondent or is discernible from the recital of the impugned order dated so and so that the transfer order was issued pending any proceedings or conciliation carried on between the workman / the employee and the petitioner employer. It appears to the court that the labor court is denuded from exercising its jurisdiction and for passing such orders, which is impugned in the present proceedings. Stop. Under such circumstances, this court is of the view that the matter will require consideration by the court, that I accordingly issue notice, a returnable 4 weeks. Since the caveator represents the respondents, notices are waived, extra copies will be furnished within a period of 1 week from today. The parties may complete their pleadings and file necessary affidavit. Till the next returnable date, the directions contained in the impugned order in respect of the transfer order passed by the respondent, passed by the petitioner, shall remain stayed. Yes.
Just click the. What I did. The order was like that, and I think the data was like that. I think it 19th of August 2025.
Where is that order?
I think this come back to 2025.
This is also for the transfer order. We'll examine it, but
Existence of the interim order
which interim order? That you have withdrawn that writ petition. No. Which labor court order are you referring to? Which was in 19/6/24. Right. What was the order passed here? The transfer order is stayed. All right, then.
Therefore, it was the about impleadment finding petition letters, which was numbered in this case P of 2025. And in that this case matter.
Where is the first order of transfer?
And only after all the comes because of the
Tell us which is the transfer order which was passed earlier. At least you should have a copy of that. $56. Hmm. So this was stayed. All right, then. Where is that order?
Because they have what they and they have suppressed the recruitment for your people. They are suppressing.
You are on caveat. You are on caveat. So if you want to oppose it, at least that the minimum materials on which you are basing your opposition. So why are you withholding to that order? No, we want to see what subsequent order was passed, which was stayed by the Labour Court.
Subsequent to the neighbors. Was it the same status in the regulation change? Same status, same history. And whether.
Well, why did you pass this order changing it when you know that there is an interim order?
That and to top of everything, whether the level 2 can go into all these things. When he doesn't have jurisdiction.
You are now agreed by which order of the Labour Court? Two orders. So,
Now, you have to carry see.
Hmm.
Put one of fight the rate petition. Who can order? Although the rate petition becomes maintained.
why is it non-maintainable?
But if you have the article 12, you have to company tax. And when they came to know that this problem will arise, they withdrew this case from here, that who can order for the level 2.
But 33, there is a provision that you will not alter the service condition. Hmm. All right, 33 itself says that you will not alter the service conditions applicable during the pendency of a proceeding. No, it does not refer to only conciliation proceedings. Pendency of any conciliation or a board or any proceeding. Yes. No, please come to 33 first. So there were two proceedings. One proceeding, he had filed an application where by which there was some injunction order. During the currency of that, you passed this order saying that the nomenclature has been changed. So what is the effect of this order? Is it a modification of the earlier order? Then Where was the necessity to pass this order when you know that the matter is sub judice before a labor court or a tribunal? No. That's the crux of the matter. Going by the submissions made in respect of the second proceedings, he's covered under 33. Now, whether the 30 may not be 33.3, but it could be 33 itself. No, why are you insisting on 33.3? 33.3 falls under 33. The opening lines of 33 gives the protection to the workman. Huh. Right, issue notice on interim. Returnable on the same date. No, he's not staying it. The facts are not clear. We'll have to examine that, Mr. Doctor. We'll have to examine that. As early as you want, but these facts are not clear. You are on a pointed query that why you are issuing the subsequent order, knowing fully well that there was an order. It may be a wrong order. It needs to be corrected. 3 weeks, returnable 3 weeks, parties may exchange pleadings. Matter be listed thereafter. Any further proceedings in the labor court will be subject to the orders passed by the court. Will be subject to the outcome of this court.
To item number 51. 51.
থাকক একো আমার এটা লাগিলে কপি এটা বনাই পেলাই আমার কারণে রাখি থব স্পাইরাল বাইন্ডিং করে ইয়েস what instructions are necessary? There is a representation. Has it been disposed of? Yes, Mr. Das. On the request made by Mr. B. Chaudhary, Learned Standing Counsel for the Respondent Finance Department, matter stands deferred, permitting him to obtain his instructions list again on 27th August. Mr. S.K. Das appears for the writ petitioner. Every date you have a problem. Firstly, when the matter is called, you are not there. Everything is the responsibility of the registry to display names of all councils. How is it possible? Huh? I can't even give you suggestions, let alone any orders, but I can certainly make a request that please maintain your diary. Don't put the entire burden on the registry. We'll refuse to accept it. When we are given a clear date, why are you relying on the registry that your names are not reflected? You know the date. Yes, 27th, 29th. All right, 29th. All right, 27th. 54. Yes. Huh? Hmm.
And Land director of land development. I said, there are the kind of for the respond number one letter. And on it's April 2025. So another question asked by the number one. What can they have on paid by us, they have for another deadline for order. Order improvement and the letter has been seven. Also, this is before the previous matter, the from the office the number one method on page seven. There are no hard.
Yes, Mr. Hendick. No, review is pending. Why notice should be issued? Passed.
Review order for without petition otherwise. The document analysis is
Yes.
What I have to pass by from the response number two without effort to comfort.
We,
Every year thing allowed by the director of management for giving opportunity of both the parts and all the relevant reports and they pass the order setting aside the solution. Profit times and it's a 19 relevant is just 19.
all right, we will issue notice, heard counsel for parties issue notice. Returnable 4 weeks. Mr. J. Hendick appears on behalf of respondent 1, 2, 1, 2, and 3. Mr. A. Chakraborty for 4, 5, 6, 7. Since the learned counsel represents the respondents 1 to 7, notices are waived, extra copies will be furnished within a period of 1 week from today. Steps on respondent number 8 by registered post AD as well as usual course. He has assumed charge, right?
Not taken.
So who will take charge of the Gaumura? Who will operate in the meantime?
And not
Any appointment, the continuation of the private respondent number 8 as a Gaumbura, if he is allowed to take charge of the post of Gaon, do you say Gaumbura, Gaon Pradhan? Gaon Pradhan of which village? Village Lakhana Bandha, post office Kurhimari, PS Ulunai, Nogao, shall be subject to the outcome of the writ petition, orders passed in the writ petition.
what I keep on your page fine. And it will
See, if the order is stayed, private respondent assuming will not be in charge of the office. You are also not in charge of the office. How are you benefited? How are you benefited by not allowing him to be in service when you also can't get into the office?
what he has to effort in time.
May not be. That is what we said, if appointed. If the government may choose not to appoint. But staying his appointment will not put you into the office.
There is a direct to
What is the direction?
direct. I got. The Indian order number 725, number 725, the Nare director of land network and started is set aside and to us. The district commissioner number is directed to proceed with the appointment of the civil officer. As the other number very
Then
because you know, first of the director of land network.
your order has been set aside. Therefore, if he is appointed, we will examine it and will be made subject to the outcome of the writ petition. If your writ petition is allowed, his appointment will be set aside. Don't pray for a stay which is not effective for you. Staying that order will not put you back into service.
TFT by the 44 years is to- and careful. On 63, it will come to the. Before the.
All right, issue notice on the stay prayer, returnable on 15th. That's all. We'll consider it on 15 to decide.
Orders item number 26.
Today, counsel for the petitioner submits that the respondents have filed an affidavit. During the course of the day, he prays for 3 weeks' time to complete his instructions in the matter. 1 week, all right. Mr. R. Bor Pujari appears for the respondent number 7, Mr. D. Nath for 5 and 6. Who has filed the affidavit? 7. The respondent 7. Counsel for petitioner prays for week's time to complete his instructions. List after 2 weeks. Yes. What, Mr.
It has been part of.
Has the defects been cleared? Has it been numbered? Then don't make the submission. Appeal has been preferred. You get your appeal numbered before the court. We'll accept your submission. When was it filed? May. We are in the end, almost at the end of August. All right. What is the direction here?
Yes. One and eight years ago. Within the period of 3 months. But the department has not been sent documents till date. And release the all pensionary benefits.
You give us instructions by next week as to the status of your appeal. Only then we can pass any conclusive orders. Heard. Heard counsel for the parties. It is submitted that an appeal has been preferred against the judgment and order dated 21/8/2023, passed in WPC 3825 of 2020, against which out of which the contempt petition arises, alleging willful disobedience of the directions contained in the order dated so and so. Mr. D. Nath, counsel appearing for respondents. Oh. Okay, Mr. M. Bhagavati appears for respondents 1 and 2. He submits that an appeal has been preferred against the said judgment. However, the status of the same is not known. He therefore submits that the matter be listed. After 1 week,
Date with this. If people in 595 days delay, help by my.
list on 3rd of August, 3rd of September. 3rd of September.
Item 28.
Hmm? What is this? You had preferred an appeal. Revenue Department. Heard Mr. A.J. Atiya, Learned Counsel for Petitioner, Mr. D. Nath, appears for the Revenue Department. No, but if an appeal is filed, then we'll have to, whatever it may be, but the court has assumed jurisdiction in an appeal, so we have to defer it. No option but to defer it. You are a opposite party in that IA. Have you entered appearance? So you contest the matter before the appellate authority because appellate jurisdiction has been invoked. It is all right, but why did you not press for dismissal of the IA? There is no submission of the opposite party reflected in the order. So very nice. Then the delay petition will have to be condoned. Delay will have to be condoned. Not at all. But once the matter is before once the order is pending before an appellate court, it is. If you have any specific authority on that point, we'd like to examine that matter on this ground. Because there are other authorities to say when an appeal has been filed, contempt proceedings should be kept in abeyance. I have understood everything, Mr. Atiya, but you are a respondent here. You did not object to the dismissal of the IA or the appeal itself. It is. So as on date, the appellate jurisdiction has been invoked. All right, heard Mr. A.J. Atiya, Learned Counsel for the petitioner, Mr. D. Nath for the respondent. This contempt petition is filed alleging willful disobedience of the directions contained in the order dated so-and-so versus so-and-so. The counsel, Mr. D. Nath had entered appearance on the request of this court, whereby the court required Mr. D. Nath to complete his instructions on behalf of respondent number 1. Mr. Nath has placed before the court an order dated 30/04/2025 passed in IA Civil 1331 of 2025. Wherein it is seen that notice has been issued, making it returnable within 4 weeks in the IA which the learned counsel submits is an IA seeking condonation of delay in preferring the accompanying appeal. Mr. Atiya, on the other end, is aware of this order being passed as he has been arrayed as a party, as an opposite party in the said IA. While the directions of the passed in the order dated so-and-so in WPC so-and-so has not yet been complied with, yet in terms of the law laid down by the apex court in so-and-so versus so-and-so, when an appeal is preferred, contempt petitions are required to be kept in abeyance, although no specific orders of stay is passed by such court. Under such circumstances, this matter be listed again after 4 weeks. Counsels are at liberty to apprise the court regarding the status of the IA along with the appeal, if the same is disposed of in the meantime.
29.
A judgment to Loilover. It will refer to Loilover. Yes. Await service report on respondent number 1. 1, 2, 3, 4, 5, 6, 7. Anyone appearing? 2 to 7. Okay. However, Mr. B. Das has entered appearance on behalf of respondent 2, 3, 4, 5, 6, 7. Stop. As such service, as such, as the respondents 2 to 7 are represented, they may file their objections, they may file their affidavit in the meantime. However, service on respondent 1 is still awaited. Matter therefore be listed after 4 weeks. No, this office note is very clear. It says 2 to 7. No, this office note rather says process service on 2 to 7, 2 to 6 is shown to be served. However, AD card not received. But respondent number 1, no AD card, no process server report is received. Okay, you are not representing 1. All right.
Second 30.
You want impleadment of finance. Any objection? Heard counsel for parties in the IA. This IA has been filed seeking impleadment of the finance department as the counsel for the petitioner submits that the issue raised in issue in the writ petition is seeking a direction for grant of pension to the petitioner. Stop. It is submitted that finance is a necessary party in the matter. Therefore, the application has been filed seeking impleadment of the finance department in the accompanying writ petition being WPC number so-and-so, as the same was not made due to oversight. Mr. J.K. Goswami, representing the opposite parties 1 to 4, does not object to the prayer made, as also MS R.M. Barua, representing the finance department, also does not object to the prayer made. Accordingly, this I stands allowed. Accordingly, considering the submissions made by the parties to the counsel for the parties, it is seen that since the issue relates to release of pension to the petitioner who claims to be the dependent, legal heir and dependent of the deceased employee, the presence of finance department as a party respondent will be necessary accordingly. This I stands allowed. Prayer for arraying the finance department as a party respondent is allowed. Finance is arrayed as respondent number 7, WPC number so and so. Petitioner will file amended course title within a period of 1 week from today. In the writ petition, you write, in view of the order passed today, Finance Department is arrayed as party respondent number 5. In view of the order passed in IE number so and so, is arrayed as party respondent number 5. The respondents, petitioner will file amended course title within a period of 1 week from today. As MSRM Borua represents the newly impleaded respondent 5 as a newly impleaded respondent finance department represented by the commissioner and secretary as respondent 5. Late notice issue, returnable 3 weeks. Since MS Borua represents finance department, notices are waived, extra copies be furnished within a period of 1 week from today. Extra copies of the writ petition shall be furnished to all the standing councils, all the council representing the respondents within 1 week from today, if not already furnished. Yes, all right.
Item 31.
I heard learned MS Zomanpui, learned counsel for the petitioner, Mr. S. Bora, representing the respondent number 1 and 2. 1, 2, and 3. No. Housing. 1 and 3. MSR Borua for respondent number 2. This I has been filed seeking impleadment of the present incumbent as in the office of the Commissioner GMC, whose arrayed as opposite parties. Stop. Learned counsel for the petitioner submits that the directions contained in the order dated so and so, passed in WPC so and so, have not yet been complied with, and therefore, in addition to the respondents in the contempt petition, the present opposite party, namely so and so, is also required to be arrayed as a party respondent, as she has now assumed office of the Commissioner, Guwahati Municipal Corporation, Panbuza, Guwahati. Stop. Para, the prayer made is not objected to by the respective council representing the respondents accordingly. Taking into consideration the submissions made without issuing notice, this I stands allowed. At this stage, MS so-and-so, opposite party MS so-and-so, is arrayed as party respondent number 4 in contempt petition number so-and-so. Stop. Petitioner will file amended course title in the registry within 1 week from today. I stands disposed of, allowed. In the contempt petition, you write, in view of the order dated so-and-so, passed in IE number so-and-so, MS so-and-so is arrayed as party respondent number 4. Stop. Mr. S. Bora, representing respondents 1 and 3, he submits that he can accept notice on behalf of the newly impleaded. Oh, okay. Impleaded as party respondent number 4. Stop. Mr. Bora represents respondent 1 and 3, MS RB Borua for respondent 2, stop late notice issue on the newly impleaded respondent number 4, returnable by 3 weeks. Steps on respondent by registered post AD as well as usual course on the newly impleaded respondent.
32.
Hmm? Hmm. What is the direction in the order?
Yeah.
Who is for PNRD? Huh?
Time.
Notice in the contempt was issued in 7/4/25. Huh. When? No, we know that you want Mr. The present incumbent's name. We are asking you whether he debited office at the time when the court issued notice. All right. Heard. I to लिखो heard. Mr. K.M. Monto. You are Mr. K.M. Monto, learned counsel representing the petitioner. This I is filed seeking impleadment of respondent opposite party number, opposite party who is the opposite party you want? The opposite party number 3 who has assumed office as the additional chief secretary to the, is there no principal secretary anymore? To the government of Assam Panchayat and Rural Development Department as Mr. J.B. As the earlier incumbent, Sri J.B. Ekka, who was the principal secretary of the Panchayat and Rural Development at demitted office. Stop. It is submitted that the directions contained in the order dated so-and-so, passed in WPC so-and-so, has not been complied with, and therefore, the present IA, therefore, the impleadment of the incumbent presently holding office as additional chief secretary to Government of Assam, PNRD department, is required to be impleaded as a party respondent. Where Mr. T.J. Monto, learned senior counsel, assisted by Ms. M.S. P. Sharma, has placed before the court a notification dated 18 August 2025, whereby the APSC has declared the results in connection with recruitment to the post of junior engineer within brackets civil under the PNRD department, Vaidi, advertisement number so and so, dated so and so. Stop. Mr. Mohanto submits that the name of the petitioner, Mr. Hemanto Kolita, is reflected as one of the selected candidates as serial number 3. 5 of them, all 5. There are 6 persons. Okay, all the 5 respondents, all the 5 applicants / the contempt petitioners have been declared to be selected for recruitment to the post of junior engineer civil under PNRD. Stop. Learned senior counsel therefore submits that the directions insofar as the APAC is concerned, direction in the order dated so and so, passed in WPC so and so, insofar as APAC is concerned, the same is complied with, as APAC is the apex body in the state for recruitment and for the selection process to be undertaken. For the posts in question, and the results have been declared. Stop. Mr. Monto, on the other hand, submits that the IA is required to be allowed as pursuant to the notification issued by the declaring the results by notification dated so and so. The PNRD is required to issue the appointment orders which have not yet been done. Stop. Under such circumstances, this court is of the view that the prayer made in the IA should be allowed. The same is allowed. The same is accordingly allowed. The opposite party, namely so and so, is arrayed as party respondent number 4 in contempt petition number so and so. IA accordingly stands allowed. Disposed of. Petitioner will file amended course title within 1 week from the registry. In the registry. In the contempt petition, you write, in view of the order passed today in IA number so and so, Sri so and so is arrayed as respondent number 4. Respondent number 3. 3. And in the IA, 3. Respondent 3. Stop. Petitioner will file amended course title in the registry within 1 week from today. Para issue notice on the newly impleaded respondent number 3, returnable 4 weeks, steps by registered post ID within 2 weeks from today. The notification dated so and so, issued by the APSC declaring the petitioners to be selected recommended for appointment to the post of junior engineer civil under Panchayat and Rural Development Department is also submitted, placed before the court by the counsel representing the APSC, is kept as a part of the case record list again after the returnable date.
Admission, I think 33.
It's been forwarded to Accountant General's office. Then this is on 15/4. No, 37, sorry. 37. No instructions. Any Accountant General standing counsel here? Hired counsel for parties, MS. Your name, please? B. Deca. Learned Standing Counsel, Elementary Education Department, has placed before the court a communication dated 30/07/2025 issued by the Deputy Secretary to the Government of Assam Department of School Education to the Accountant General, conveying the sanction of rupees 2,32,618. Stop. Para, the counsel for the petitioner on the other end submits that the petitioner has not received the amount stated to have been sanctioned by the department till date. Stop. On the request made by the court, Mr. B. Chakraborty, learned counsel representing the Accountant General. Is Accountant General a party here? All right, has appeared before the court, and he's permitted to take instructions on this communication and apprise the court on the next date. Let the matter be listed again. When can you get it? 10 days time. All right, on 10th of September. 10th of September.
Item 34 to 36.
Yes, Mr. Goswami. Heard counsel for parties. The respondents have not yet filed their pleadings. Be it as it may, the matters be listed for admission after 2 weeks. In the meantime, if the the respondents may file their counter affidavits, if so advised. Otherwise, the court will proceed to hear the matter on the basis of materials available on record. 57.
These are covered by the subsequent order that I have placed the other day. That is
All right, let all these matters come up after 2 weeks for admission hearing. The date you want? 4th September.
37.
Last order. You are directed to file. What time you have been granted time till on 37? So we are not responsible for that. We have asked you to file it, you file it. Why have you not filed it? In deference to the earlier order dated so-and-so, 3007/2025, Council for the Sri Bhumi Municipal Board, Executive Officer, who are you representing? Who is Respondent 5? Executive Officer. Is this Karimganj? Sri Bhumi. Karimganj, Sri Bhumi within bracket earlier erstwhile Karimganj, bracket close, Municipal Board. No, is it Karimganj Municipal Board, Sri Bhumi? Name has been changed of the board by some notification. All right. Sri Bhumi Municipal Board. Audited accounts, copies of the audited accounts have been placed before the courts. Where is the report of the auditor? See, first you must understand what was there in the order. Then you must communicate it to your client. So have you understood what the court directed you to do? What? You have not read the order. Do you have a copy of this order? You don't have a copy of the order. It is available online. We'll read it for you. File audited accounts and a report by the certified auditor. It has to be accompanied by a report. Copies of audited report, audited bank state, audited report is stated to have been placed before the court. The council submits that he had received these reports only yesterday. They to DD. He prays for further 10 days time. Considering the prayer made, matter stands deferred to be listed immediately after 10 days, by which time it is expected that the respondents will file their audited reports, audited accounts, along with a report by the certified auditor showing the financial health of the said municipal corporation. In the event these documents as directed are not filed, court will proceed to pass consequential orders as deemed fit and proper. List this matter on 2nd of September. Any objections? 2 weeks. Heard counsel for the petitioner, counsel for the respondent renews his prayer for further 2 weeks time to file his objections. Prayer made is not objected to by the counsel for the petitioner. Accordingly, the matter stands deferred to be listed again 2 weeks, after 2 weeks. Eighth of September.
Section 40.
At the request of the council for the petitioner, matter stands passed over for the day. Mr. Ghosh appears for the PNRD department. Yes. We are passing it over for the day. You renew your prayer if permitted by the court.
42.
Mr. Faridi appears for the petitioner, Mr. B. Chakraborty, learned CGC for the respondent. Mr. Chakraborty renews his prayer for further time. He prays for 3 weeks, 3 weeks time. Accordingly, let the matter be listed. Again, after 3 weeks, interim order passed earlier will continue. List again on 19th September. Yes? Right.
43.
Yes.
Last time we give it, I with my team.
What are you challenging? What is the effect of the speaking order? Your 2 increments have been pursuant to an inquiry. Any appeals filed before the authority? Where is that speaking order? 40. This is the order passed by the disciplinary authority. Any appeal filed against that? You are still working. Right, that doesn't mean that you will keep on praying for time. If you want to file something, you file it within 2 weeks, no further. Not 3 weeks, 2 weeks. What is there to file? This is the matter of, it's a speaking order. How are you going to improve or defend the speaking order? What is your ground for challenge? (24). Where is amended writ petition? 24. Yes. Curtailment of 2 increments is the punishment imposed. We're not asking you that. Tell us what is the effect of the speaking order. That is the punishment. So you want the punishment to be removed, to be interfered with. So are you challenging the proceedings? Are you challenging on what grounds do you want the punishment to be interfered with? Huh. All right. Where is the inquiry report? Not here? Then how do you say the nothing has been found against you? Where is the inquiry report? Where is the show cause notice? Yes. Hmm.
Three penalty inflicting punishment of punishment of impleadment. Qualifying promotion and scope in future with a provision for in the implementing service. And now penalty destroyed. The chief said suspension order has been blocked. Therefore, the question of inflicting punishment for punishment implement.
How are they two connected? What has suspension got to do with curtailment of increment? Is this pursuant to an inquiry? You were served with a show cause. Huh? No show cause. No reply.
They have no objection to this discussion. There is also
No, no. Was there any inquiry held? What do you mean, perhaps? Then how are you before the court? On what ground are you challenging it? Why we are not a superior appellate authority. You are invoking the writ jurisdiction for what purpose? No, what is the ground for challenge?
in the
Hmm. No, no. For any charges to be proved, for anything to be proved, there must be charges framed. Was it framed? You are the petitioner. You have no instruction, and you are opposing the prayer for filing counter affidavits. You have amended the petition. Still no instructions. So therefore, we are asking you, why are you challenging it? For what? On what grounds? What has got curtailment got to do with suspension? If you are suspended, your period is considered to be on duty, you are entitled to pay. So what has increment got to do with it? Heard counsel for parties on the prayer made by the counsel for the respondent, the matter stands deferred to be listed after 3 weeks. The respondents will file their affidavits and bring on record any proceedings that may have been undertaken against the petitioner before imposition of the punishment. List accordingly.
44.
Hmm. Some instructions here required to bring on additional affidavit. Where is what? We will start imposing cost if you don't file it. Mr. So-and-so, Mr. K. Colita appears for the petitioner, MS S. Borua for the state, who renews a prayer for further time to bring on record the additional affidavit. Purely for the ends of justice, matter stands deferred to be listed after 2 weeks. 2 weeks, enabling the respondents to file their additional affidavit. It is made clear that no further adjournments on this ground shall be allowed. List on 5th. এইটো matter item হৈ গ'লতো।
Item 45.
আমি বেলেগ দুনিয়াত গুচি গৈছি নেকি? Yes. Blacksmith. Oh. They have filed an affidavit. Additional. It's not on record. All right. Mr. D. Upamanyu, counsel for the petitioner, submits that an affidavit, additional affidavit has been filed in the course of the day. Mr. Abdullah, learned counsel appearing for the petitioner, submits that he would like to obtain more instructions in the matter, and therefore prays for week's time. 1 week. Prays for a week's time. Let the matter be listed again after 1 week. Meanwhile, registry will ensure the additional affidavit stated to have been filed by the respondents to be brought on record before the next date fixed. List on 4th September.
46.
Yes, Mr. Goswami, any instructions here?
This is not for appointment. Now, so that's okay.
All right, since the pleadings are complete, matter be listed for admission hearing on 28th August. You'll hear?
47.
Yeah, of blanket votes.
Yes. You urge before the arbitrator. Otherwise, where is the clause? Arbitration clause? 33. This is a railway. So we'll pass orders. Railway appointment or order doesn't. That clause 64. 64 rupees. That was silo. Their orders. Petition allowed. We appoint Mr. Justice P.K. Musari, former judge of the Guwahati High Court, to act as an arbitrator, sole arbitrator, to decide the disputes and differences arising between the parties on the basis of the agreement executed, contract agreement number so and so, page 27. This is 27 is the contract agreement, number so and so, dated so and so. Stop. The parties will appear before the learned arbitrator, prospective arbitrator appointed by this court within 2 weeks from today. And the learned arbitrator will thereafter furnish in writing the, what is that? Arbitration agreement, act, declaration, written declaration under section 12, under section 12 of the Arbitration and Conciliation Act. (12.1). Matter be listed again on 10th of September, by which date the written declaration furnished by the learned prospective arbitrator be placed before the court. Copy of this order shall be also marked to Mr. Justice so-and-so, retired former judge, Guwahati High Court, who's the prospective arbitrator appointed by this court. Yes. List on so-and-so, the 10th.
48.
Yes. Yes, anything to do? All right. Matter be listed for admission hearing on 11th September, as the pleadings are complete. heard so and so counsel. Now, V. Kumar for petitioner, B. Chakraborty for respondents. 4950, similar. 48, 49, 50, petitioner's name is same. B. Chakraborty in item 48, CKS Borua 49, R.K. Dev Chaudhary in 50. All right.
Similarly, for admission item 65,
Yes. Huh? Pleadings, affidavit filed. Why? We'll start imposing cost to be recovered from the hearing officers. We'll give you 1 week's time. File your affidavit. 1 week. MS L. Wajida, Learned Counsel, appears for the petitioner. MS M. Kolita for the respondent. PHE, who submits that, who renews her prayer for further time to file affidavit. List this matter again after 10 days, by which time the respondents are expected to complete their instructions and file necessary affidavit. After 10 days.
56,
Petitioner, counsel at the bar submits that the pleadings are complete. The matter can be listed for admission hearing. List again on 28th August. Follow? Counsel for the respondent submits that this matter be listed along with WPC number 1443 of 24, 4883 of 24. List all these matters on 28th.